Now, please look at on the second element, that is acceptance. You know what is acceptance? Yes, acceptance means what? Penerimaan. And we have several definitions. We have several rules laid down under acceptance. The first one, we have section 2 subsection B. Okay, this is the definition of acceptance. It means when you signifies your assent and it is said to be accepted and it becomes a promise. Next, how it can be made. This is laid down under section 9. Yes, it can be made orally, in writing, or by conduct. It means it can be made expressly or impliedly. Next, we look at on the main rule on acceptance. For acceptance, I want you to focus on these 3 rules and try to remember the important section here. We have section 7A, 7B, and section 4 subsection 2. First, we look at on section 7A. Under section 7A, it says that acceptance must be absolute and unqualified. Yes. What is absolute? What is unqualified? Absolute means it must be made on exactly the same terms without modification or variation. This is the meaning here. Okay, please remember. And otherwise, it may amount to counter offer or rejection of offer. And this has been discussed in the case of height versus range. You have to remember, for height versus range, in this case, the court laid down the 2 rules here. First, what we have discussed on termination, it means counter offer may amount to termination. And second one, for this rule, counter offer, it amounts to modification or variation of price. That's why the court considered there was no contract. Alright, shall we move to the next? Yes, we have on how we are going to differentiate between counter offer and also request or inquiry. First, we need to know what is request actually. Request means when you ask the person regarding the information of the goods or maybe delivery of the goods and others, okay, anything about the goods or services. It didn't involve a modification of price. And we have 2 cases here that will be discussed under this part on request. We have the case of Stevenson. Yes, we have Stevenson, Jacks and Co. versus McLean, the first case. Look at the facts of the case. The defendant offered plaintiff to sell iron and he said that he would open the offer till Monday. On Monday, what happened? The plaintiff asked about method of delivery, which may be considered as an inquiry. but later the defendant sold the iron to someone else. In this case, we need to consider whether there is a counter offer or not.